Welcome to the 13th episode of Legal Affairs. I'm Stephen Yap. Good afternoon. On the 30th of March 2022, when the President of the United Kingdom's Supreme Court, Lord Robert Reid, resigned as a non-permanent judge of the Hong Kong Court of Final Appeal, together with his deputy, Lord Patrick Hodge. In the studio today, we have Mr. Ian Grenville Cross, Senior Counsel. Mr. Cross is an English barrister who was appointed Director of Public Prosecutions of Hong Kong on the 15th of October 1997 and has held this post for over 12 years until the 21st of October 2009. He is now an Honorary Professor of Law at the University of Hong Kong. He was also the first Director of Public Prosecutions to be appointed after the transfer of sovereignty of Hong Kong on the 1st of July. Mr. Cross is here to give us more insights on this issue. Mr. Cross, do you think the Hong Kong court has an enviable reputation for the quality of justice delivered?
Well, of course, the Hong Kong Court of Final Appeal succeeded the Privy Council as the ultimate appellate body for Hong Kong in 1997. The judges in the Privy Council were of exceptional quality, all coming from the United Kingdom. But despite the standards that they had to try to meet, in my view, they've done a tremendous job. And of course, it's been a mixture of local Hong Kong judges and overseas judges from major common law jurisdictions. And they've pooled their respective talents. They've inspired the confidence of the people in Hong Kong in the standards of their legal judgments. And indeed their judgments are widely respected, not only in Hong Kong, but around the common law world. And it's quite gratifying to see that from time to time the Hong Kong Court of Final Appeals judgments are actually cited with approval in other jurisdictions. So I would say, to answer your question, Stephen, that the Court of Final Appeal has undoubtedly been one of the big success stories of Hong Kong over the past 25 years and has contributed very significantly to the rule of law, which of course is why Hong Kong's rule of law is so highly regarded by objective observers, such as the World Justice Project, which in its recent Rule of Law Index ranked Hong Kong at 19th out of the 139 jurisdictions which had been surveyed, which was an impressive standing, well ahead, for example, of the United States. And that standing, in my view, is largely down to the high quality of our judiciary, and in particular, the Court of Final Appeal.
So is it important that we have foreign judges sitting on the top court of Hong Kong?
Well, it's a remarkable experiment that Hong Kong embarked upon, having foreign judges sitting here. And it was a great show of faith in Hong Kong's legal arrangements that Beijing agreed that this could happen. What you've got to remember is that in other major common law jurisdictions, such as Australia, Canada, United Kingdom and so on, this does not happen. The ultimate appellate court is always composed of local judges. But Beijing decided to go the extra mile to allow foreign judges to participate in the work of the Court of Final Appeal, which, as I say, was a great show of faith. Now, why did they do that? Obviously, I'm not privy to their innermost thoughts, but I would imagine it was due to the fact that they took the view that the Hong Kong was an international city, that it had always been plugged into the traditions of the common law world, that there was a long tradition of overseas judges sitting as judges in Hong Kong, and that Hong Kong stood to benefit by having a number of overseas judges available to sit on the Court of Final Appeal. I think as well they realised that it would be an indication of continuity after 1997, given that there had been involvement by overseas judges prior to 1997. I think as well they realised that some people were a bit nervous about the future after 1997, and they tried to allay those concerns by having overseas judges available to sit in the Court of Final Appeal. I think the business world would also find the presence of overseas judges to be reassuring, and indeed so it has turned out. And as I say, it has turned out to be a great Hong Kong success story.
Would you agree that judges drawn from countries other than the United Kingdom would be a future development?
Well, of course, at the moment they are drawn from Australia, from Canada, from United Kingdom, and from New Zealand. The judges for those 4 jurisdictions have been called to sit since 1997. There are, in fact, about 80 common law jurisdictions around the world, and under the Basic Law there is no restriction on which of those common law jurisdictions can be approached to supply judges. So my view is that the net can certainly be cast far more widely than it already is. There's no need to stick to those 4 particular jurisdictions at all. And if there are judges of a very high quality who are willing and ready and able to come to Hong Kong to sit, then there's absolutely no reason why they should not be invited to sit. And I think of various places in this part of the world. I'm sure there are eminent judges, for example, from Singapore or Malaysia. In Europe, I mean, Ireland would be a possibility, another very well-known European common law jurisdiction. And in the Caribbean, with which I believe you have some connections. Yes. There are very highly regarded judges over there, including places like Jamaica. So there's absolutely no reason at all why the net should not be cast more widely over the next 25 years.
So would you also agree that the required capacity to serve should not be determined by simple reference to whether a person has previously served as a judge, but instead by reference to a more holistic need?
Well, if by that you mean is private judicial experience not absolutely necessary, then that's certainly right. A classic example of that is Lord Jonathan Sumption, who sits on the Court of Final Appeal in Hong Kong now, and is widely regarded in England as being the brainiest man in the country. So we're very fortunate to have a judge like that. He hadn't been a permanent judge in the United Kingdom before that, as most of his contemporaries were. Most of them made their way up. So it certainly can be done, but I would imagine that for the most part, it's better to try and select people who have a proven track record of judicial experience, because obviously if they have that, there's more to judge on, more to base a decision on as to whether to invite them to sit or not, because you can refer to previous judgments that they've issued and so on, and assess them in that way. So in practical terms, it's probably better if appointees do have past judicial experience, but as I say, people like Lord Sumption have shown, it's not absolutely necessary. And of course here in Hong Kong there have been very eminent lawyers who've gone straight to the Court of Appeal, and one thinks, for example, of Henry Lytton in the 1990s, and of course don't forget the first Chief Justice of Hong Kong in 1997, yes. The first Chief Justice of the Court of Final Appeal, and Andrew Lee. He was not a permanent judge before that, so he went straight from the bar to being a member of the Court of Final Appeal, and he made a highly distinguished contribution. So there are exceptions, as I say. It's not absolutely necessary to appoint someone with judicial experience, but sometimes it can be an advantage to know from their track record just how good they are.
So Lord Reid and Lord Hodge recently resigned as the non-permanent judges of the Court of Final Appeal. How concerned are you about this?
Well, Stephen, I'm obviously sad to see them go because they were highly capable judges, but I'm not particularly concerned at all. I mean, the big story here is not that 2 judges resigned, but that the bulk of the judges have made absolutely clear that they're going to stay put, and that they feel that their duty is to serve Hong Kong to the best of their ability, and that they're able to do this without any interference from outside sources. Indeed, the former Chief Justice of Canada, Justice Beverly McLachlan, just the other day made the point that she was able to operate independently here in Hong Kong, that there was a high quality of justice available to the people of Hong Kong, and she wanted to be a part of that. And she said that obviously if there was any political interference or outside interference on the work of the court, then she would leave. But that point certainly hasn't been reached, and hopefully it never will be reached. So yes, I am concerned, but I also recognise the context in which they have resigned. You have to remember that there has been a campaign for some time in the United Kingdom and in the United States and elsewhere to pressurise judges to withdraw from the Hong Kong Court of Final Appeal. This is partly to undermine one country, 2 systems, and partly to undermine the rule of law, because it's recognised that if one country, 2 systems does very well, then this reflects well on China, and they want to undermine Hong Kong's legal system in order to damage China indirectly. And the judges themselves have been put in a very difficult position because the British government has made it clear that the British judges should not be sitting. And so that puts people like Lord Reid and Lord Hodge in a very difficult position. But the big encouragement, of course, is that the the 10 remaining judges have all indicated their absolute commitment to Hong Kong and their belief in the rule of law in Hong Kong. As we said earlier, there are 10 judges, and if that's not enough, then we can certainly start recruiting from elsewhere. But certainly for the foreseeable future, I believe we probably do have enough judges, but if we don't, then as we've discussed, places like India, Jamaica and Singapore could be asked to provide replacements.
Okay, thank you, Mr. Cross. That's the programme for today. Thank you for watching Legal Affairs. See you next time.
Thank you.
Thank you.